Any adjournment request? Table list for motion. Item number 1.
May I please?
PIT and DPS.
PIT and DPS Lordship. Representation was not considered or not reflected in the final order, Lordship.
What are the grounds?
Page 15 is the impugn order that was initially passed by the authority, detaining authority, Lordship.
Repeated offender.
Lordship, 4 cases are pending as mentioned in the order, impugn order.
Hmm.
But petitioner, husband of the petitioner is on bail, Lordship, and facing the trial, Lordship.
In all the 4 cases.
All 4 cases. And without any default, Lordship.
You also get the records how the satisfaction is reached.
Lordship.
Time to go. You file your affidavit and get the records. And the preventive detention is to be disposed of expeditiously. When? Next Thursday. Next Thursday. Next Wednesday. Will issue notice. But they get the records also. If he has got bail in all the 4 cases. Third, Mr. M.K. Hussain. Learned counsel for the petitioner. Mr. D.K. Sharma, learned traditional senior government advocate, Assam, for the response number 1, 2, 1, 2, 8. And Mr. K.K. Porahar, Central Government Council, for the response number 9. Full stop. The petitioner in this petition instituted under Article 226 of the Constitution as a seal and order dated 18/2/2025 within bracket NXI passed by the response number 2 under section 3 within bracket 1 of the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988 within bracket PIT and DPS Act for short. Whereby the petitioner has been detained,
Husband of
the husband of the petitioner, Mohammed MD Ramizul Haq, has been detained until further orders. Until further order. Full stop. Where in the ground of detention, dated 18/2/2025, it is mentioned that the detainee is found persistently involved in illegal business of narcotic drugs for many years and was arrested in connection with four number of cases. PS 24 as a 1, 2, 3, 4 Rupoihar police station. Close to Para. The Land Council for the petitioner has submitted that in all the aforementioned cases, comma, the detainee was enlarged on bail and he has not violated any of the terms and conditions set forth in the orders whereby he was granted bail. You place the bail orders by affidavit next day. The counsel for the petitioner has submitted that he will furnish the bail orders, copies of the bail orders by way of an additional affidavit within a week. You should notice as the matter is, you should notice returnable in as the matter is of preventive detention command. You should notice you should notice first as the matter is of preventive detention. Command, the notice is made returnable on next Wednesday. The learn it as Mr. So-and-so appeared and accepted notice. Extra copies by today. The affidavits of the respondent. The respondents will ensure that the affidavits are filed on or before the next date of listing. Post of the London State Council shall also obtain the necessary records for perusal of the court on necessary records. Shall also be ready with the necessary records on the next date of listing.
Stand up, wait, Item number 9.
Your Lordship, the petitioner's daughter admittedly has been declared as a foreigner by the competent foreigners tribunal, Your Lordship. Thereafter, Your Lordship, that order has been upheld by this honorable court. But on 25/5/2025, Your Lordship, police authorities visited house in the darkness of the night and picked her up. And
Yes, were detained
where-
or kept holding your new concept holding area.
Take inspection.
Huh? This is emanating out of foreigner issue, right?
Yes, Your Lordship.
Heard Mr. I. Hussein. Counsel for the petitioner. CGC? Mr. D.K. Sharma, Learned Traditional Senior Government Advocate, Assam for as per number 2, 3, 4, and 5. Postal. The petitioner has instituted the instant writ petition. Under Article 226 of the Constitution of India, seeking a writ in the nature of habeas corpus. And stroke or any other appropriate writ, order, or direction. Because of the case of the petition is that the petitioner's daughter,
Daughter.
Afia Begum, who was was picked when has been picked up,
Case 6 to your worship, clarified
has been picked up from her matrimonial home at
on the 25/5/2025.
matrimonial home where?
Your lordship, Golaghat, your lordship.
Huh?
Golaghat, your lordship.
Golaghat on 25/5/2025 by police personnel from Komargaon Police Station along with officials from the border branch. Postal. And since then, the whereabouts of Afia Begum is not known to the petitioner.
No.
Postal. Para. It has been stated that in a proceeding registered as case number FTG para 3 stroke D-96/07 before the Foreigners Tribunal at Jorhat, Afia Begum was declared as a foreigner by an order stroke opinion dated 6/11/2015 as a foreigner who entered into the territory of India after 24/25 March 1971 by an order stroke opinion dated 6/11/2025. Full stop. When Afia Begum
6/11/15, your lordship.
15. When Afia Begum preferred a writ petition command WPC number 4779/2016 against the order stroke opinion dated 6/11/2015, before this court. The said writ petition was dismissed. When? By an order dated 21/8/2018. As it is contended that whereabout of Afia Begum is not known to the petitioner, the state respondents shall obtain instructions as regards our whereabout and place the instruction before this court on next Monday. Whereabout? No. Monday. A phone call. We can fix it at 2 also. Para. The Land Council for the petitioner supply a copy, an extra copy of the writ petition along with the annexes, to Mr. R.K. Devchuri, Learned Deputy Solicitor General of India for service upon the respondent number 2 and to Mr. Sharma, Learned Traditional Senior Government of Assam for obtaining necessary instructions. for the state response during the course of the day. This is the case on so.
For admission, item number 2.
Mr. I.S. Mojumdar. Heard, Mr. I.S. Mojumdar. Learned counsel for the accused appellant. And Miss S.H. Bora. Learned additional public prosecutor for the respondent state. This criminal appeal under 4152 BNSS 2023 is preferred against a judgment and or judgment dated 2/4/2025 and an order on sentence dated 5/4/2025 passed by the Court of Learned Sessions Judge Kamrup at Aminggaon in Sessions case number 95 of 2014 postal by the said judgment and order on sentence, the accused appellant has been convicted for the offense under section 302, Indian Penal Code. And she has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000, in default of payment of fine, to undergo simple imprisonment for further 3 months. Full stop. We have gone through the contents of the memorandum of the bill. The criminal appeal is admitted for a hearing. The case records of Sessions case number 95 of 2014 are to be put for issue notice returnable in 4 weeks as Ms. Bora and additional public prosecutor has appeared and accepted notice on behalf of the respondent state. Issuance of formal notice to the state respondent is dispensed with. Extra copy of memo of appeal within 3 working days from date. This is the case after 4 weeks. Art, Mr. I.S. Mojumdar, Learned counsel for the applicant appellant, and Ms. S.H. Bora, learned additional public prosecutor for the opposing party as respondent state of Assam. The instant application under section 430 BNSS 2023 is preferred seeking suspension of execution of a sentence passed against the applicant appellant and for her release on bail. The applicant as the appellant has prepared the accompanying criminal appeal pursuant so again the issue notice returnable in 4 weeks as Ms. Bora has appeared accepted. Petition the opposite party issuing the problem of this dispensed with and the state is to file its objection to the instant application before the next date of listing.
Item 3 for orders.
Also,
My lord, in this case, paper book is not ready.
Part Miss P.R.A. Sultana, Learned Legal Aid Counsel for the appellant and Miss S.H. Bora, Learned Additional Public Prosecutor for the respondent number 1, State of Assam, post of as per order dated 5/2/2025, service of notice upon the respondent number 2 is complete. Lozima court is complete. Full stop. Legal aid or discipline. As none has appeared to represent the respondent number 2, comma, we deem it proper to appoint. Okay. Ms. Meghali Burman from the panel, Land Council from the panel of legal counsel to represent the respondent number 2 in this appeal. Closed up as the case records from the Land Special Court have been received, comma, office to prepare the paper book. Closed up release the case after 4 weeks for a report as regards the release of the paper book.
Item 4,
Moshe, here LCR has been received, and no paper book is prepared. Please wrote to matter.
The learned amicus query for the appellant is on absent to the uncalled. Ms. B. Priya, learned senior counsel and additional public prosecutor, listed by Ms. M. Das, R. Das, learned counsel for the state. Is in attendance. Miss,
I'm on behalf of MSP Church,
your name,
Instant Color.
you. A case records of sessions case number 47 so 2019 have been received. So that our office to prepare the paper book. Leave the case after 4 weeks for a report as regards the release of the paper book.
items 5 and 6.
Okay, you have to come. It is Miss Bobnia, it is continuing the music case. No, music case is pending there.
No, it was against me, so
Item 7,
What's this IIS for suspension of the MP
You
judgment?
have to issue notice then. Huh? You file objection. Heard, Mr.
J. Hatimuria.
J. Hatimuria. Learned counsel for the applicant appellant. And Miss S. H. Bora. Learned additional public prosecutor. For the respondent. Number 1, opposite party number 1 state. First of all. Instant application under section 430. Within bracket 2. BNSS ground entry is preferred by the applicant. Appellant seeking suspension of execution of the sentence passed against it and for his release on bail issue notice returnable in 4 weeks. As Ms. Swara, an additional public prosecutor has appeared and accepted notice on behalf of the opposite party. Number 1, state issuance of formal notice to opposite party number 1 is dispensed with. The applicant shall take step for service of notice upon the opposite party number 2 by registered post within within 3 working days post. The objection of the state respondent and state is to be filed on or before the returnable date. Post the opposite party number 2. If he appears upon service of notice, he is at liberty to file. He is also at liberty to file an objection.
Like this.
item number 8,
Lordship, this is an adjudicatory application under section 5 of limitation of delay of
Hard Miss
PM Ahmed.
PM Ahmed. Yes, Miss Bora. Right. Counsel for the applicant appellant. and Ms. S.H. Boral and additional public prosecutor for the opposite party number 1, State Assam. So, this is an application under section 5 of the Limitation Act 1963, seeking condonation of delay of 1 day, which has occurred in filing the accompanying criminal appeal under section 415, B and S as 2023. Where the applicant, as the appellant has referred the accompanying criminal appeal against the judgment and order dated 26/3/2025 passed by the Court of Learned Additional Session Judge FTC Sri Bhumi in Sessions Case Number 32 of 2016. Posted by the judgment and order dated so and so. The applicant appellant has been convicted for the offense. Says both are offenses under section 376 IPC. And under section 6 POCSO Act. First of, the applicant appellant has been sentenced to undergo rigorous imprisonment. Rigorous imprisonment for 10 years.
Barriers, so then it comes to.
370 sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 10,000, with default stipulation. Close stop. The applicant appellant is also has also been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 20,000 with default stipulation, under section 6 POCSO Act. Close stop. Again, we have gone through so and so good. And the opposite party too will be hard at the stage of appeal for this responsibility.
Much of it.
This, we are thinking that it will be an expeditious hearing. Interest of justice will be subsequently. 1 day delay. For 1 day delay, it will be 1 year. Service of notice, legal aid, counsel, objection. And then main restart will, appeal will be restarted after 1 year.
For hearing. I don't
Oh.
know.
May it please your lordship. Lordship is to pass the last part of the judgment.
from the, it is evident from the evidence of materials on record, there was no eyewitness to the incident of assault on the deceased. Evidently, the case of the prosecution is based on circumstantial evidence. Full stop. Para. Before. Any no, yeah, before on perusal of the judgment and order of the learned trial court, we find that the trial court has taken the following circumstances to be conclusively established page 133 of the paper book 1 to 6. Upon analysis of the entire evidence stock materials on record, including the testimony of the prosecution witnesses, including the medical evidence and the testimony of PW. Dr. Dutta. PW 26. PW 23 and PW 26. We find ourselves in agreement with a trial court as regards the first three circumstances enumerated above. The disease dying inside the house, death beside you. Relevant time construction work going on, Binu Mahato, Mania Munda, divided. On perusal of the statements given by the two accused persons who faced the trial, comma, it is noticed that the accused, comma, Mania Munda, admitted to the extent that admitted in his statement given under section 3131B CRPC, to the extent that he and the appellant were working in the house of the deceased, Dalima Dotto, for masonry works. When the same incrementary circumstance as regards presence of both the accused persons facing the trial was put to the appellant at the stage of 3131B TRPC. The response given by the appellant was not similar to the ones given by the other accused, Binu Mania Munda. So the appellant hearing in his reply to the circumstance that both he and Mania Munda were working in the house of the deceased, Dalima Dotto on the date of the incident, the appellant denied the same with a plea of falsity in the prosecution case. one. Itu fifth circumstance. Yes. On the fifth circumstance referred to by the trial court is found to be, as per the testimony of the prosecution witnesses, referred therein. Full stop. It is on the basis of the sixth circumstance, that is non-explanation on the part of the appellant the trial court had taken it to be an additional circumstance. It appears that the trial court had taken it as an additional circumstance in a chain of circumstance and treated it as a circumstance completing the chain. Pointing the guilt, pointing towards the involvement of the apple in the crime committed. We now turn to the circumstances, which, according to the prosecution, are incriminatory to the present appellant. According to the prosecution, the adverse circumstances are, firstly, there was seizure of a hammer. Semicolon. Secondly, there was seizure of a wearing apparel of the appellant, that is, one light blue half sporting Ganji without collar with suspected blood stains. Thirdly, the appellant was found to be present at the PO, that is the house of the deceased, since before the incident. Fourthly, এই আহতি যে নাটক করছে যে নাটক করেছে Before, who are the prosecution witnesses who testified that Arati had reenacted the crime scene? Wherein this appellant was implicated? Many have said, right? Please, please.
EW 20.
One, two, serially, go by serially, from 1 to 30. Take us to that point. Ten. Now, basically, I don't know. My mother is
Six,
six.
BW six,
Six.
BW six, for Chandra Bhatta.
Okay.
Case number 24.
24.
Apprehended a woman RT by name and she showed police how she along with the national Jogali and she had committed the incident. BW six, then
Page
24.
24.
PW6, page 24.
Page 24 where
Ajit Dutta, brother.
Ojit Dutta.
Ajit Dutta, brother, police came. Divine.
Last.
24. Okay.
24, then lordship. Ten lordship, BW 10,
PW 10,
10.
page
Page number 34 lordship where she have stated. BW 10, 33.
33.
34. 33 starts lordship
Hmm.
and 34 lordship. Last RT told us. BW 10 is the sun,
Son, 34,
34 where she
told us.
lordship.
This 34. PW 11.
Page 36 was. Page 36, second line.
Where is the
Then lordship, BW 20.
photographer?
BW 20 page number 56.
PW
20.
20. No,
Page
Last
number
part, last part.
56, last part.
20. Rosie. 19. Santono. 20. PW 20.
Page 56. last part.
Brother-in-law. Page,
56 last part.
last part.
I came to learn.
PW 21.
21 also say page 60. Third line, Bharati gave a demonstration as to how Dali Madhutta was killed.
The woman narrated from the entire page 63. UPW 22.
Constable.
Still. Page number 63. Fourth line.
Scene.
One 25 Lordship.
The increase was done.
Serving as a photographer.
CID.
CID that page number 69. Fifth line. The woman showed Gladstone clothes in a during said came to the is confessed to have committed the incident.
It is a confusion on the part of the Bharati.
Page number 29 where she was writing first chapter saying.
50.
Page number 84, PW 29. Second
And-
paragraph,
What about the IO?
page 7.
That The absconding accused, Arati Tati, had confessed regarding involvement, regarding her involvement, as well as the involvement of the present appellant in the crime. And 60, the appellant failed to provide a plausible explanation during his statement recorded on the section 3131B CRPC. According to the prosecution, when the circumstances established have pointed towards the involvement of the appellant in the crime, the appellant owed an explanation under section 106 Evidence Act to disclose the facts which were specific within his knowledge. And such failure has provided the additional link to complete the chain of circumstances. First of all, para. Yes, madam, when where the IO said about the arrest of the persons. Kalimun what litigation? Kalimun what litigation? Unarrested. That's the litigation.
Lordship, page number 74, Lordship.
74.
74, middle portion, Lordship.
Ah.
I also arrested Vidu Mohato, Banya Munda, Ganesh Tanti in this case on 11/1.
Middle.
Lordship, 1. Twenty-four, 25.
Or
That is Lordship, after Dilip Senwal lodged the formal letter. Exhibit 1.
I also.
I also arrested 11/1.
From the in his testimony, Commander IO PW 26 stated that all the accused persons, Arati tenda agote korise na mane. I also, so after the arrest of Arati Tati, the IO, he arrested the three accused persons, one Binu Mahato, the appellant bracket, Mania Munda and Ganesh Tati in connection with the case on 11/1/2008. Postal, para. As per the testimony of CW 29. The Sardha ceremony was on 16/1/2008. And it was on that day, Arati Tati confessed regarding the incident. And how Dalima Datta was murdered by three of them after hatching a conspiracy. Full stop. PW 29 has further stated that the confession of Arati Datta was videographed. Oh. Okay. Twenty-nine, no? 25. Is 68. PW 25, the photographer of the CID, deposed to the effect that he recorded a proceeding in both audio and video form after a meal. After two persons, one male and one female were apprehended. According to him, as per his testimony, the woman was serving as a housemaid and a male person was working as a mason in the house of the deceased. Full stop. The woman had confessed that she had committed the act of murder. Full stop. It's W22, no? পিছন উপটল করে দিব সিরিয়ালি করবো পিডব্লিউকে PW 22. The police constable, stated that the accused, Arati Tati, narrated how the entire incident was committed and the narration made by the said accused person was video recorded. The said video recording was captured in a compact disc, MAT.ext. Which was seized by a serial list ext4. Yes, 21. 60. As per the testimony of PW 21, police apprehended the housemate, the accused, ROT, and a mason, full stop, after apprehending after few days after apprehending them, police brought them to the house of the deceased. And on that day, the accused ROT gave a demonstration as to how Dalima Datta was killed. And police recorded the entire incident of narration and demonstration given by video record, given by ROT Datta Pustav. At the time, PW 21 stated that at the time such narration and demonstration was given by ROT Tati, large number of persons, including all the neighbors, almost all the neighbors were present. Poster. 20. PW 20, page
56. Last part.
as per PW 20, he came to learn from the accused, RV Tati, as he stated before him that she kept at the time of committing the act, Dalima Datta was held by her, and it was the apple who inflicted the cuts on her. Stop. PW 14. PW 14. Seizure him.
14 did not tell.
Hmm?
14 did not say about.
He is a seizure witness.
Seizure.
PW 14, 11. 11 page 36.
36.
PW 11 testified to the effect that police apprehended the accused person, R.D. Tati. And thereafter, R.D. Tati narrated before him, her, how she, with the assistance of the two masons, killed Dalima Dotto, killer deceased, PW10. PW10 stated that it was R.T. Tati who told them how, who did tell them about the manner in which she, with the help of the appellant, hacked the deceased with a dao. PW6. PW6. PW6 stated that police apprehended the housemaid, Aroti, and it was she who showed the police personnel how she, along with the two accused persons who faced the trial, had committed the incident. Also, there are a the incident that occurred on 9/1/2008. So seizure. Where is the seizure? From her house. In case seizure 142. One 90 belonging to the deceased with suspected blood stains was stated to have been seized at 11 a.m. on 10/1/2008. on being laid and shown by the accused person, Arati Tati. During a search in the house of the deceased. Full stop. As per the seizure list, the nightie was kept concealed in the Allah. Allah. What is the English of Allah? Huh? Not Allah is not Almida. Allah here. ALNA. Bishop Boldo লিখিত। Full stop. কিবা আগত হৈছে নেকি কিবা? আগত কিবা হৈছিল নেকি? চিজাৰ 10 তাৰিখৰ আগতে 10 তাৰিখে হ'ল। 10 তাৰিখ। বাকী বস্তুটো এইটো 10 তাৰিখ। এইটো 10। এই মাত্ৰ যে ক'লো এইটো 10টো। 10। On being late, না? Incident between? No. Evidence accumulation. As per section 25 of the Evidence Act, no confession made to a police officer shall be proved as against a person accused of any offense. The rule of evidence contained in section 26 of the Evidence Act contains a bar to the effect that no confession made by any person whilst he is in the custody of a police officer, unless it be made in the immediate presence of a magistrate, shall be proved as against such person. Full stop. Now, section 27 of the Evidence Act is an exception to section 26 of the Evidence Act. Full stop. it has been consistently held that Section 25 and Section 26 have been enacted. Not because the law presumed the statements to be untruthful, but having regard to the tainted nature of the source of the evidence, comma, they are prohibited from being received in evidence. Also, any confession made to a police officer is inadmissible. Therefore, any admission made to a police officer is inadmissible under Section 25 of the Evidence Act, and that ban is extended also through Section 26 to the confession made to any other person also, if the confessor was then in police custody. Also, such custody need not necessarily be post-arrest custody. Also, the custody used in Section 26 is to be understood in a pragmatic sense. First of, if any accused is within the ken of surveillance of the police during which his or her movements are restricted, then it can be regarded as custodial surveillance for the purpose of the two sections. First of, if he or she makes any confession during that period to any person, be he not a police officer, comma, such confession would also be hedged within the band contours outlined in Section 26 of the Evidence Act. Full stop. When with such principle of law as regards admissibility or otherwise of a confession made within a person within the ken of surveillance of a police officer, the fact regarding narration or fact regarding reenacting the crime scene by the accused person, comma, Aroti Tati, comma, which is stated to be videographed, comma, is clearly inadmissible in law in view of the bar contained in Section 25 and 26 of the Evidence Act. So as a corollary, comma, any confession made by the said accused person implicating the present appellant hearing is also to be disregarded, being inadmissible in law. We also find the evidence regarding recovery of the hammer. We will also find that the evidence regarding the evidence insofar as the recovery of the hammer is also is inconsistent. Full stop. IO, what he said? IO. hammer. As per the testimony of the IO PW 27, one iron hammer was seized from the roof of the house of the deceased. White. Seizure list. Seizure list. 153. It is 153. EXT8. So stop. As per the seizure list, EXT8, comma. The hammer, the iron hammer, with a bamboo butt, was found in the, that is pakka chat, sad, English. Floor, roof, concrete roof of the RCC house of the deceased. With the assistance of the sniffer dog of the CID. In presence on the start roof
IO said that it is roof. It's hard believe it. Sad. It's
In presence of witnesses, comma, PW 15, PW 19, and PW 30. Full stop. PW 30 was the dog master of the sniffer dog. Full stop. In his testimony, comma, PW 30 stated that, yes, very easy. 80. The sniffer dog was made to smell all the things in the house of the deceased at first, and thereafter, comma, the sniffer dog led them to a house at a distance of about 1 to 1.5 kilometers. And it was in that house, comma, one hammer was seized by police. White. The seizure list, comma, EXT7, where he gave his signature. EXT8, where he gives his signature as EXT84. Also, PW 30 further testified that at the house was at Kokratoli, where from the hammer was seized, and wherein the hammer was found. And at that time, comma, there was no one in the house. Also, serial list, hammer. PW 19. Let's see PW 19. PW 19. 52. PW 19 mentioned about the sniffer dog and the seizure list, ext8. Full stop. He stated that he had forgotten where he put his signature ext82 in the seizure list. Full stop. He failed to name the persons who, apart from him, put his signature in the seizure list ext8. Full stop. PW 19 further stated that he did not know, we could not say whether the seizure list ext8 was written up or not when his signature was taken by police. And PW 15. 15. এটা উপরটা তৈরি করি PW 19 further stated that he could not say why police obtained his signature in the serial list ext8. First of PW 15. PW 15 বানাইনি huh? ext8 page 44, which part? On the other hand, no, so, PXT 15, PW 15 stated that he exhibited a seizure list as ext8, whereby a DAO was seized. Post of para. In view of such inconsistent testimony as regards the place of seizure and the manner of seizure of the iron hammer, Matt ext was that exhibited? Hammer was exhibited or not exhibited? Hmm? No, Matt, the material exhibition. Comma. The evidence regarding
Material exhibit 3 also.
Matt ext3. The entire evidence regarding the hammer is found to be clouded and doubtful. Full stop. Para. provide a seizure list, comma, NG EXT 10. One light blue half sporting Genji without collar with suspected blood stains was seized from the possession of the appellant at 11:30 a.m. on 11/1/2007. Should be 2008 perhaps. 2008. In presence of 3 witnesses. Julhas is what? Julhas. PW 17. Mihir Bordhan.
Mihir Bordhan was not examined.
Comma, Mihir Bordhan, within bracket, not a witness. And Vodro. And PW
14.
14. Full stop. Para. Oh, no, not para. PW 14. As per the testimony of PW 14, comma, no. But when we examine, when we have gone through the testimony of PW 14, we find that he did not mention anything about the seizure of the said wedding apparel of the appellant. আরোটা করেছিল আরোটা করেছিল মানে ভদ্র জুলহাস PW 17 page 40. Page 40. PW 17. As per PW 17, comma, his signature was obtained in the seizure list EXT 10 when he visited the police station on a particular day, postal, but he did not know what kind of material was seized by the seizure list, comma, EXT 10. Postal. When the wearing apparel of the appellant seized by the EXT 10, comma, was sent for examination to the FSL, comma, the FSL report
174.
serological examination, comma, the scientific officer FSL submitted a report dated 26/2/2008 within bracket EXT 15. After its serological examination, post of as per the result of the serological examination, comma, the wearing apparel, comma, seized by EXT upon the appellant, comma, seized by the seized by the seizure list EXT 10, comma, gave negative test for presence of blood stains. Post. Para. Y en caso de Brasil. So, in various itu body mass weight medium. Body mass itu sama. Pera. It is submitted on behalf of the appellant that the set of evidence against the two accused persons who faced the trial, comma, were seen. And in view of the acquittal of the other accused person, comma, Mania Munda, comma, the case of the appellant is required to be examined on the principle of parity. Full stop. Video 34 is no. Video 34. 34. 34 was there. 34 was there. It has been apprised that the order of acquittal passed in favor of the other accused person, comma, Mania Munda, has become final as no appeal has been preferred by the state challenging the judgment and order dated 11/12/2019. Passed in criminal appeal within bracket J number 53/2016 within bracket Mania Munda versus State of Assam by a coordinate bench of this court. Post. On the other hand, comma, it is contended on behalf of the state that merely because The state did not file an appeal against the order of acquittal of Mania Munda. Comma. The appellate court, this appellate court can go for appreciation of the evidence on record on its own, notwithstanding the order of acquittal of the other accused person. Full stop. Fair. State prerogative. It is contended that the appellant could not have been convicted for the offense under section 302 IPC with the aid of section 34 IPC in view of acquittal of the other accused persons. Full stop. Where the power of the appellate court in dealing with an appeal, as defined in section 386 1B CRPC against an order of conviction and appreciation of evidence is as wide as that of the trial court, and it has full power to review the whole evidence. So the appellate court is entitled to go into the entire evidence and all the relevant circumstances to arrive at its own conclusion about the guilt or innocence of the accused person. Full stop. In Sundar Singh versus State of Punjab, AIR 1962 SC 1211, it has been held that the appellate provision in the code do not create a bar against the appellate court from considering indirectly and incidentally a case against a the person who was acquitted, if that becomes necessary when dealing with the case in the appeal presented on behalf of the other accused who is convicted. In considering the evidence as a whole, the appellate court may come to the conclusion that the evidence against the person acquitted was also good and need not have been discarded. When several persons were alleged to have committed an offense in furtherance of the common intention, and all except one are acquitted, it is open to the appellate court to find out on a reappraisal of the evidence that some of the accused persons have been wrongly acquitted, although it could not interfere with such acquittal in the absence of an appeal by the state. Full stop. The effect of such a finding is not to reverse the order of acquittal into one of conviction or visit the acquitted person with criminal liability. Full stop. The finding is relevant only in invoking against the convicted person his constructive criminality. Full stop. Para. Mr. Hassan, will complete it tomorrow. So many witnesses, and it is very difficult in absence. Sitting alone. Will be. We'll also observe, we'll find out 106 also we have to deal with. And also the observation of the coordinate bands. We have to agree with that. But 30 witnesses has made the task difficult with so many. Put that case tomorrow. Yes.
CCI matter, Dalmia Cement is a CCI.
Hmm.
Slight development in this. So the DG's report, I believe, has been submitted with the commission. And I believe the party will be seen of the report soon. If that be the case, then it'll have to be seen whether anything's right.
DG's report.
The section 26. So if you honor recall, the process was under section 26(1), a prima facie opinion is formed. An order is passed to that effect. That is the order that is under challenge in this report. And a consequent notice. And that order now has been held to be valid and proper. It's challenged before the division bench also. That is also upheld. And consequent to that order, the DG is reported. And all the remedies now are available for the commission, so they'll be able to give objections, they'll have a hearing, the whole process is there. That's my submission.
Yes, Mr. Bora.
After vacation also.
Okay.
Only submission request, Your Honor, would be that the learner ASG and school can make the term of the date may be. That's my request.
P.K. Bora. Joint Council for the petition. Didas. Joint Council for the response number 2 and 3. Mr. B. Chaudhary, Joint Council for the response number 4. Heart. Postal. Joint Council for the parties have submitted that a similar issue is presently pending before the division bench, or not division bench. And they are awaiting the outcome of the division bench. First of Mr. Das has further submitted that the Director General CCI has passed an order,
Submitted the report.
has comma in the meantime, comma, submitted a report. Any other provision Any provision?
26(7), I think.
under section
26(3).
26
26(3).
3 of the Competition Act. Two thousand two. The copies of the report will be furnished to the concert parties
As per the provision.
as per the statutory provisions. First of where with such projections, the land council for the parties have sought registering the case. After the ensuing summary application was to. As sought for and agreed to by everyone present for the parties, is that is on side you. Like August. First week. Six,
Apply solution.
6 8.
You're not 70.
It is on 6 8
I might be out of town. Still.
4 4 8
Five, earlier.
or 11 8
11.
11 also fine.
11.
Apply solution.
For motion, item number one.
Please, your lordship. So this is third application lordship. And this is a charge sheeted case lordship.
Hmm.
Lordship. This case has been already been amicably settled lordship between the respondent and me lordship. This is
Go to the trial court then.
lordship.
There is no question of granting any bail.
So some protection may be given lordship. Because this is the
Either it is yes or it is no.
this is a
Depends on the section 65 and subsection 2 of section 70 of the Bharatiya Nyaya Samhita. Hmm?